Thank you for coming today. I'm going to be speaking on religion in the United States, the role of religion from a legal and constitutional perspective. It's going to be a little technical, so I apologize. It's not going to be as interesting and fun as the previous presentation, so you guys, if you want to doze off, that's fine, or have some coffee, that's good too. But I'm going to explain a little bit about how the Supreme Court of the United States and federal courts have interpreted the concept and role of religion in the lives of Americans. And we of course have to begin with this foundational documents, which is the U.S. Constitution. So, and all of these involve cases, meaning disputes that have arisen between people and the government. And those disputes are known as lawsuits. So somebody files a lawsuit, or the government files a lawsuit against a private person, or the private person files a lawsuit against the government, saying that their religious liberties have been violated. And then it goes up the system. In the United States, there are two different kinds of court systems. There's a state court system and there's a federal court system, right? So Illinois has three types of courts. The state of Illinois has the trial court, the appellate court, and a Supreme Court. And you have the same in the federal system. So you have federal district courts, which are the trial courts. Then above them, you have what's called the circuit courts. And then after that, you have the United States Supreme Court. That's the one most people are familiar with. Okay? And those are the ones that we'll be discussing. Those are the ones that get to the U.S. Supreme Court. Let's see. Okay. So within the U.S. Constitution, you have these phrases or clauses. I guess the analogy would be verses, in a sense, that talk about the first free exercise and the Establishment Clause. But then you also have some federal laws that Congress passed, and those are known as statutes, federal statutes. That's another source of law that people look to. And then you also have state constitutions and state laws. So in Illinois, you have the Illinois Constitution. And you also have state laws that discuss, or at least give rights, if you would say, about people's religions and so forth. Okay. I'll give you an example. You also have federal laws that were passed in the 1960s because of the civil rights movement that talk about religion as well. So first question I'll just kind of ask you guys is it a violation of the U.S. Constitution for your local masjid to terminate someone based upon their race or because of anti-women basis? Yes or no?
It's a violation, yes.
No, yeah.
Anybody say no? Yeah, right, that's true. Why?
I was expecting to trick you, but
Yeah, I know, it's very easy. Why? It's because of this act. Okay, the reason this is important is because most of the time, religious institutions like churches and so forth, they pretty much have wide discretion to do what they want. They can hire, a Christian organization or a Jewish organization, they can hire Jews and Christians, obviously, for their own particular purpose, right? However, because of the 1964 Civil Rights Act, you cannot discriminate even if you're a religious organization based upon race and things like that. Okay, so that's what that's referring to. In 1993, there was another statute that was passed called the Religious Freedom Restoration Act, which again provides certain forms of religious protection for people across the board, regardless of who you are, whether you're a Christian, Jew, Muslim, whatever. And then there was another act that was passed in the year 2000 by bipartisan support, which means that it was like 98 senators passed in favor of this bill, both Democrats and Republicans. And this is the very awkwardly phrased Religious Land Use and Institutionalized Persons Act, or RLUPA for short, that was passed in 2000. And this protects specifically churches, synagogues, and masajid from discrimination by local zoning boards. So if you want to build a masjid somewhere and you buy a piece of property and you want to build it, you have to get permits, right? You have to go to the zoning board and ask for permission for building and permits and so forth. If they deny you because of discrimination, this act protects you. What's interesting is that most of the Muslim community did not even know this act existed until maybe 5-10 years ago. I'll give you a more specific example on this. Or you know what, I'll come back to this later. And then also states have passed the State Religious Freedom Restoration Act. I'll come back to Arlupa because it's actually quite interesting. All right. These are the foundational documents of the United States. Okay. The first was the Declaration of Independence that was filed in 1976, right? Thomas Jefferson wrote that. And it was basically exactly what it says. It's a declaration of freedom from Britain. And then after they declared freedom, there was a document that 13 colonies, former British colonies, passed and signed into to work out their relationships between the different states. This was known as the Articles of Confederation. So if you can see, that's 1781. But this did not work out very well. So as a result, you had a constitution that was passed in 1789. Okay, and that's why, because the Articles of Confederation didn't really work out well, the 13 colonies decided to go ahead and ratify what's called a U.S. Constitution 1789. But we're going to focus on the religious aspect here. Why did religion become an important issue for the United States when they passed the Constitution? First, because it was the part of religious history in Europe. Most of the people that came to this country, formed this country, were Christian, of Christian background. You also had, in the early 19th century, the rise of what's known as the Great Awakening. This is a major Christian movement that begins to disassociate itself again from Britain and the clerical establishment. I would say this is similar to kind of what you would call, what I think your previous speaker was talking about. Did he talk about Salafism? Salafis? Did he talk about that?
No.
Not really? Once? Okay. Yeah. This is similar to that, meaning that Salafism is a return, so-called return to the text, as opposed to institutions, right? So this Great Awakening movement was similar to that, which is the idea of getting away from the religious institutions, the clergy, and the clerical establishment power, and instead returning to the people and the text. The text meaning the Bible in that context. Okay? And the third influence was, of course, what's called the Enlightenment, the sort of secular Enlightenment philosophical movement that begins in Europe, again, in the mid-18th century, in places like France, Germany, and later on in England. Really, Germany was very important because of scholars such as Immanuel Kant, who became a very pivotal figure in really resetting the role of religion in the world, in Europe, in the European context, and a very important British thinker called John Locke. John Locke wrote a very important book on government and the relationship between government and people and religion. So all these ideas are floating around at the time that these people who formed this country and wrote the Constitution were influenced by. So you have religion, you have history, and of course you got the Enlightenment movement that affected how and why they want to put these provisions in the U.S. Constitution. Now, when you had these states that were created, each state had its own idea of what role religion will play in that state. So the early sort of governments that were formed in places like New England, and that would be Massachusetts, Vermont, Rhode Island, these were founded by a group of Christians called the Puritans. You probably heard of Puritans, maybe your children are familiar with Puritans and when you study grammar school. And these were formed by what's known as the Congregational Church. It was the Congregational Church. And they have a particular unique, interesting way of understanding their religion. A second one, very important state, was Virginia. Virginia is where Thomas Jefferson lived. It's where George Washington lived. It's where James Madison, who actually drafted the U.S. Constitution, was from. So Virginia was one of the most important central states in the early founding of this country. And those people came and were dominated by what's known as the Church of England. This is the Anglican Church. Okay, from England, the Anglican Church was the big important church. And then you had others from Pennsylvania, for example. Again, Pennsylvania, another important church. The city of Philadelphia was important for the founding of this country. And there, it was dominated by Quakers, another offshoot. So you have these different churches and groups, right, who are part of the early period here, and they're looking at religion in different ways. And as I mentioned, Madison and Jefferson were very, very important. And by this time period, we're talking about the 1780s, 1790s, you have this discussion of religion going on and the role of religion. Why? How much do we want religion to be part of our government and lives? And what's interesting here is that these people, even though they came from a Christian background, they did not want to adopt a particular church. And this would be similar to saying, for example, if you were an Ottoman, should the Ottomans, or even the Turkish government after 1920, should they adopt a particular madhab, right? Well, we all know the Ottomans adopted not only Sunni Islam, but they adopted the Hanafi madhab, by and large, right? They promoted the Hanafi madhab. Same thing with the Abbasiya Empire, they promoted the Hanafi madhab. But later on, others did something different. So this is similar to what's going on here. The question is, should the early states here, different states and the founders, should they adopt one of these churches as a form of government and following? Should it be the Anglican Church? Should it be the Congregational Church? Should it be Baptist Church, whatever, and so forth? What they decided to do is, if they were to choose one church, it would upset somebody else. And it would create controversy. So they didn't want to adopt a particular church as a founding government in this country. And I'm going to skip because of lack of time. There's some issue here that was, in the state of Virginia, there was an act that was passed, or at least promoted, to provide funding to churches, for example. And Thomas Jefferson and James Madison lobbied against that bill, and they won. And that laid the foundation then of the reason as to why in the U.S. Constitution you have this reference. In Article 3, you have this idea of where you're going to have this test. Here we go. So what happens is, after the U.S. Constitution is passed, there's some lingering issues that are going on. One of the lingering issues is the role of religion in the U.S. Constitution. So in 1789, the U.S. Constitution is adopted, ratified, and then a few years later, they start adding to the Constitution. Those additions are known as amendments. Now, you may have heard the term Bill of Rights. The Bill of Rights, right? Those are amendments, basically. And the first 10 of those amendments to the U.S. Constitution are known as the Bill of Rights. One of the first amendments deals with religion and freedom of speech. But we're going to focus on the freedom of religion. And this is it right here. It says, it says, Congress shall make no law respecting an establishment of religion or prohibit the free exercise thereof. This is pretty much all that the U.S. Constitution says about religion, aside from saying that there's no religious test. So the Constitution says that there should never be a religious test to be required as a qualification for any office or public trust. In other words, you don't have to be Christian, Jew, or atheist to become an office holder or to run for Congress and so forth. It's very important. All right. But getting back to the religion clauses, it says respecting an establishment of religion or prohibiting. In other words, Congress cannot pass a law establishing a church. It cannot pass a law that says we are going to promote baptism, or Baptist religion, or the Quakers, or the Jews, or whoever. At the same time, it cannot deny people's ability to practice their religion. Okay? So it's kind of interesting because there's tension between these two clauses. On the one hand, you cannot promote religion, but on the other hand, you can't deny people's religion. Right? So that's it. And it's from this clause you get hundreds of disputes and cases later on. Now, the first 100 years after this was adopted, there's not much really disputes going on in the US. Why? Because everybody is the same religion, predominantly white Christians, and mostly Protestants. Right? Yes?
Did they have other religions in mind when they were writing this, or they are just referring to different branches of Christianity?
I think they did have other religions in mind, but I don't think that was the main issue. Because there were Catholics around, there was Jews around, but very small numbers. There were Jews actually around in small pockets. And there's a very famous episode in Jewish history where the first president of the United States, Washington, visits a synagogue in, I think it was New York, if I remember correctly.
You know, like it's somewhat related. I think, like Thomas Jefferson has once said that, like our democracy is such that even the Mohammedans comes to this and then, like they vote a Muslim, like let it be kind of, like understanding, I guess. They had this, like the larger religious understanding rather than, like the only, so that's kind of the clue to me, like that's what they had.
Yeah, I just don't think that Jews and Muslims were really in their mindset as much.
They were not there, but
Yeah.
like, they were kind of describing their democracy, like.
Yeah. And by the way, when they talk about Muslims, they often refer to Turks. Like in their references and documents, they mention the word Turk, and that's what they usually mean by Muslims, because that's what the only Muslims they knew at that time was the Ottoman Empire. And there are treaties between the United States and the Ottoman Empire early on as well. Anyway, this slide is simply saying, you don't have that many cases up until really later on in the century. Okay, what types of cases trigger this dispute about what we call the Establishment Clause? The Establishment Clause means that the government cannot promote a particular church or religion. Usually nowadays it involves these areas: taxpayers supporting private school, prayer in school, like in public school, public-private monuments such as the Ten Commandments. In the news you often hear so-and-so wants to put a statue or some kind of frame of the Ten Commandments in some government building, and all of a sudden it triggers this issue and you have lawsuits. And of course, public prayer and meetings. Now, there are three views historically about how to interpret the Establishment Clause. Right? Three views. One is what we call the wall of separation. This is the famous phrase known as the separation of church and state. Notice, so far, when I'm talking about this issue, this is the first time I mentioned to you separation of church and state. Why? Because it's actually not in the Constitution. And it's not used until the 1940s. Please tell Brother Shefki, his father's trying to get a hold of it. Okay, so the first one is this idea of being a strict separation between church and state, meaning we don't want the government at all supporting any churches or religious institutions. A second view is that there should be neutrality, meaning you go on a case-by-case basis, and the government should simply be neutral depending on what is being asked of them. And then third is a more accommodationist perspective of religion. In other words, we want to accommodate religion into the state and federal bureaucracy in some capacity. Usually this means in terms of funding of some kind or another. All right. The first major case that really kind of takes this issue and sets what's called a precedent. A precedent is where once a case is decided, then everybody sort of follows that case. Okay? I'm trying to think in Islam how that works. It's similar to in Islamic law too, where you have a case established in a madhab, for example, and then everybody follows that madhab, and next thing you know, it becomes a madhab. You know, you have a certain school that views and follows a particular pattern of behavior, and that becomes the established precedent. That's how Islamic law works too. Anyway, so there's a case that was very important called Emerson versus Board of Education. And here, the justice who actually used the phrase separation of church and state was this guy named Hugo Black. Justice Hugo Black, who's pictured here, was a very important Supreme Court justice in the 20th century who wrote some of the defining opinions on civil rights in particular, and of course religion. And he's the one who wrote this opinion. I'll skip this stuff and so forth. Okay. And after this case was passed, let me go back for a second. This was a situation where the government, it was a state government. I want to say it was either Pennsylvania or Rhode Island, whereby the state wanted to pay for tax benefits to a Catholic school so that it can go ahead and get some tax benefits. And ultimately, it went to the Supreme Court, and the Supreme Court said, no, you can't do that because you're favoring a state. And that's when he wrote this separation of church and state, okay? But then you don't really see a major case until 1963. And this was important, and it set a very important precedent on the Establishment Clause. Number one was that Pennsylvania, the state of Pennsylvania passed a law in a school district saying that every morning, every public school in that district has to begin the day by reading 10 verses from the Bible and the Lord's Prayer. So this was a legislation that was passed, and it went into effect in 1959. So of course what happens? Somebody sues. Somebody sues this government and says this is a violation of the Establishment Clause of the U.S. Constitution. It goes up. The district wins in the federal district court. Then it goes up to the appeals court. They win again. And then it goes up to the Supreme Court. The Supreme Court rules in favor of the student family that sued. It was a student's family that sued the government. All right. And it was an 8-1 decision by the Supreme Court. And it said that this law that's passed is invalid. Why? Because number one, it must have a secular purpose. In other words, when legislators make legislation and pass a law, in dealing with these issues, they have to have a secular purpose, and the primary purpose of that law should not be to advance a particular religion. Now, if you think about it, that's pretty amazing. It's pretty amazing that you have a dominant Christian majority in the state of Pennsylvania that can pass laws that help themselves, and yet they refrain and don't do that, right? Historically speaking. But they did that, of course, in 1959. And why is this happening? Can anyone tell me what, if you know about American history in the 1950s, what was going on in the 1950s?
Black issues.
After the Second World War,
No.
Just around this time, they allowed teaching evolution in classes.
Now think about globally what's going on in the 1950s. What's the biggest issue? Yeah, communism. The United States is scared crazy about communism. And what's communism stand for? Atheism against religion, first and foremost. So a lot of United States legislators, both at the federal and state level, are scared of communism, especially the Republican Party. So they're going around passing all kinds of legislation to try to undermine communism. One of the ways is to promote religion. So, you know, you've heard the Pledge of Allegiance, right? When does it get enacted? 1950s, yeah. 1952, 53, I think. Why? Okay, because of communism. So all that's going on. So you see this, the same thing going on. Anyway, so the Supreme Court says, sorry, Pennsylvania, this law that you passed is unconstitutional, and they reject the law. So this now becomes a very famous case that now begins to be followed throughout the country. All right. Finally, you come to this other very important case, which sets a precedent for like 20 years, called Lemon versus Kurzman. Again, this one has to do again with public schools and districts. Here, in 1968, Pennsylvania passed a law authorizing public funds to be used for non-public schools, like private schools. In other words, simply to help teachers for textbooks, instructional materials, and so forth. In other words, the law would help provide for free these materials to Catholic schools or other private schooling, but mainly it was Catholic in this context because the Catholics run a lot of private schools in this country. So then this went up, okay, and it went to the Supreme Court. So the Supreme Court developed what's called the Lemon test. Okay, what is a test? A test in law is how do you interpret this Constitution? How do you interpret any law, right? And there's tools. It's kind of like saying tafsir. It's similar to the concept of tafsir. What are the tools of interpretation of the Quran? Why? Because many phrases of the Quran are ambiguous, okay? And we don't know exactly what the true meaning could be. So what do? You apply tools of interpretation. What's one tool? One tool is, well, you look at a Quranic verse through another Quranic verse, right? That's called a tool of analysis. Another tool of analysis, well, what did the Prophet ﷺ say about this hadith, right? In other words, you look to hadith. Another one is, well, what was the historical circumstances of when this verse was revealed, right? So these are called tools of analyses and interpretation. Similarly, you have this kind as well. So this tool, sort of test was adopted by the Supreme Court that says every law that is passed or proposed must have, number one, a secular purpose. Its primary effect should neither advance nor prohibit religion, just like the previous Emerson test. I'm sorry, the Schempp test. And then they have this third analysis, which is no excessive entanglement of religion. So what happens is you have these Supreme Court justices who have this case that's brought to them, and then one of the Supreme Court Chief Justice assigns a case to somebody, one of the justices. They look at it and say, okay, how are we going to address this issue? And they negotiate with themselves and say, okay, we're going to adopt this kind of test. And once you can get a majority of justices, 4 or 5, then that view prevails for that case. So that's what happens here. And they decide that we're going to go ahead and use this to interpret that phrase, and therefore they held that the Pennsylvania case and also a similar case in Rhode Island were unconstitutional by 8-0 and 8-1. That's pretty, predominant. Okay? It said that because the laws were supporting private or religious institutions, it involved an unnecessary, excessive entanglement of religion into the state function. Again, pretty extraordinary. Why did this happen also? Remember, this is 1971. What was going on in 1971 around that time?
Cuban crisis.
I know, that was much later. Civil rights. Right? This is post-civil rights. This is 1968. The country is fighting with itself about Vietnam. Robert Kennedy is assassinated. MLK is assassinated. So there's a movement that we don't want to promote a particular religion and that we want more diversity in the country and so forth. That's why this case became so important. All right. I'll just kind of go through really quickly because we're kind of going up the time. So what happens here? In the 1980s, you have these cases that are still fought sometimes, whereby Christian organizations are trying to push what we call the envelope and test the court system. So what they do is they put up these displays at this time, which is Christmas time. You'll see these all around, right? Most of the time you see on people's homes, churches, of course, but what happens when it's on government property? When it's on government property, and you as a minority like us Muslim, we think, oh wow, the government is supporting Christmas, right? Or supporting this. And as a result of this, you now have these cases that go to the Supreme Court. So this one came, I think this one was also Philadelphia. I don't know what it is in Pennsylvania. They seem to like litigation a lot. So this is what's called a nativity scene. The nativity scene refers to the story of Mary and Jesus and Joseph just before, just after the birth of Jesus in the Christian tradition, and these wise men visit them. That's called a nativity scene. You'll find these in many places. So someone goes ahead and puts this on the government. Okay? Now here, in this particular case, let me see, what was that? Was that Lynch? Yeah, okay. Now, this is an interesting scene because why? What do you see here in this scene? You have the religious stuff right here, right? That's baby Jesus, that's Joseph, that's Mary, the three wise men, I believe. But what else do you see? You have Santa Claus, the reindeer, ribbons, happy holiday sign. So what does the Supreme Court do? They rule 5-4, it's constitutional. Why? Because they're saying this scene is not an advancement of religion, and it's part of American secular history to promote during Christmas time these kinds of displays. And there's what's called a dissolution of the scene, which is what? The reindeer and Santa Claus. The reindeer and Santa Claus saved this case. Yeah, believe it or not. And it also concluded that, you know what? America is a religious country and historically, and we're not anti-religion. So we're going to rule. But it's a close decision, 5-4. Brother Safki, did you get your message?
It is not my debt.
Oh.
Let me explain, brothers Ahmed, that
Okay.
somebody called me and said, okay, so your debt is calling my debt. My debt is already dead.
Oh, astaghfirullah. Oh, yeah, okay, sorry. All right. Okay. Now, let's look at another scene. This is in New York. This is in New York, where you have a display. It's not a great picture, but you have a display of the Christmas tree, a Jewish menorah. And then inside, this is the government building here. This is the county building. And then you've got inside the building, another nativity scene, what's called a creche. It's hard to see in this picture, but it's all religious stuff, only religious stuff. So this case, again, someone sues, it goes up to the Supreme Court. Okay? Here, this was a Catholic group that puts up the nativity scene inside the staircase of the courthouse. Okay? It has a sign that says, "Glory to God in the highest," in Latin. There's no reindeers, no Santa Claus. Outside, a Jewish group puts up a menorah, okay? And then someone put a Christmas tree. So the Supreme Court rules that this scene inside is unconstitutional. This outside, the Christmas tree and the menorah, are constitutional. So they kind of split. Yeah. Why? Because here, it's a combination of different faiths appearing. Okay, they're not really promoting a particular religion. They're kind of promoting an idea of Christmas, and the Christmas tree does not have any specific religious aspect to it. It's a secular symbol. Okay, and same thing with the menorah. That's what they rule. Whereas inside the house, in the courthouse, you have inside the courthouse, within where the others are outside, a promotion of religion, pure and simple, both in terms of verbal signage and the nativity scene. All right, yeah. Okay, and then you have these other kinds of cases with the Ten Commandments and things like that, which they kind of, so in other words, people have gotten very sophisticated, and so has the Supreme Court, that a little thing here or there, where the symbol is displayed, is it outside, is it inside, is it part of the historical aspect of, of this country? Is it new? Are they promoting a particular faith and so forth? So all these little details really matter now in these tests. All right, you have a sense now, right, of how the Establishment Clause works? Okay, so for example, this here, is someone tried to put this display in the Texas Capitol, and they ruled that this was constitutional because it was okay. Historically, they used to do this. But there was another one that they put inside the building. Again, that was ruled out. So you have all these kinds of things going on. I'm going to skip some of this other stuff because it's too technical. All right, now that's what we call the Establishment Clause. This is where the government gets involved. But now we're going to talk about free exercise, meaning the government cannot deny the free exercise of your faith. Our ability to practice our faith, the government cannot deny that. So now this is a different category of cases, right? So you have the Establishment Clause cases and what we call the free exercise cases. These are more interesting because they're more personal. And the first 100 years, you really don't have any disputes, okay? But after initially 1870 and then after the 1940s, now you have these cases almost every year in the U.S. Supreme Court, okay? The first major case was called Reynolds versus the United States. And this is something that most Muslim men can probably relate to, because in this case, this involved a Mormon gentleman who had 2 wives, all right? And in 1861, actually 1859, Congress passed a law, and then in 1860 is ratified by Abraham Lincoln. And he was arrested and then charged with what's called bigamy, meaning having more than 1 wife, usually 2 wives. And he said, well, this is, being a Mormon, this is part of my faith. I'm required to have more than 1 wife. It went to the Supreme Court, and the Supreme Court ruled against him and said, that's true, but this is violation of our laws around the United States. It's against our public policy. And then they also explained different reasons, which I'm not sure will work today, but this is 1879. And then you have what's called Jehovah Witnesses. You guys have heard of Jehovah Witnesses? These are the people that come knocking on your door and asking you to, read the Bible and so forth. It became a very common practice in the 1940s. And then same thing with Seventh-day Adventists and so forth. I'll talk a little about these. These are fun cases. Okay, and we just talked about this. Okay, the Reynolds case, the court ruled that we cannot sort of regulate private religious practices. However, once they affect public interest, then we can. And then it ruled that Reynolds violated the bigamy law by saying if religious beliefs were superior to the laws of the land, then every citizen would become a law unto itself. In other words, everybody would just promote whatever they want without consideration of the wider interests of the public and the country. All right. Here, these Jehovah's Witnesses were outside in the public square passing out literature, promoting, their religion and also anti-Catholic faith and things like that. In order to protest or pass out any of this in Connecticut back in the 1940s, you needed a permit. And they were arrested and charged with not obtaining a lawful permit to distribute their religious literature. And when they tried to do that, they were denied the permit. So they sued. It went to the Supreme Court. And the Supreme Court ruled that the law that prohibited them from passing out the religious literature was unconstitutional because it was a denial of their free exercise to promote their faith. So that's where you begin to see now from the 1940s on these important kinds of cases. In 1963, you have a very important case called Sherbert versus Werner, and this is an interesting case. It was a woman who worked for, I think it was the Postal Service or some government agency. I think it was a government agency. And she was there working many years. And then she converted to the religion of what's called Seventh-day Adventists. Does anybody know Seventh-day Adventists? No? It's a form of Protestant, but they're very similar in their practices to Jews. So they do not work on Saturday. They follow the Sabbath, and they also don't eat pork. Okay? So they told her, they changed her schedule, and they wanted her to work on Saturdays. And she said, I can't work on Saturday because I practice Seventh-day Adventist. I'm forbidden. I perform the Sabbath. So they fired her. They terminated her employment. She said that's a violation of my rights, so she sues. It goes up to the Supreme Court. The Supreme Court rules that we're going to use this test for free exercise. The test is this. If the government imposes a substantial burden on someone's ability to practice their faith, they have to show that the law that was passed is absolutely necessary for the government. In other words, the government's interest is more important than the person's practicing of their faith's interest. And they have to be able to show that this is very important. It's absolutely necessary to pass this law. The government ruled against the Supreme Court ruled against the government and in her favor, and said that the government violated her free exercise because making her work on Saturday was not that important. They could have found other ways, and forcing her to give up her religious right so that they can force her to work is against her religious rights. It's a violation of religious freedom. Again, as I mentioned in the Establishment Clause, you had the Lemon test, right? The 3 analyses. Similar in the exercise area, you have these tests called rational tests, intermediate scrutiny, and strict scrutiny. What that basically means is what happened in the Sherbert test, which was that whenever you have somebody whose free exercise of civil rights are being attacked by the government has to show that this legislation is absolutely necessary. And they need to have a very important government interest to promote over the exercise of someone's rights. I'm just going to skip this one here. Oh, this is another important test. This is from 1971, or 72, I think. Here, it's another, I'm highlighting the cases that are kind of similar to what we would face as a community. So Wisconsin passes a law saying every single student must attend high school, public high school, every student. And if they don't, then they must attend a comparable private school. So there's a group of people called the Amish. Have you heard of Amish? Mm-hmm. Amish people. They have their own lifestyle. They live separately from everybody else. They kind of work the land. They don't use electricity, and things like that. So they didn't want to send their kids to public school at all, or private school. They home teach, on their farms and so forth. Wisconsin then charged these people with violating this law. So what did they do? They sued. It goes up to the Supreme Court. Supreme Court rules 6-1 that while the state of Wisconsin does have an obligation to promote education, that's their obligation to promote education, but that obligation has to be balanced with the person's religious obligation. And the government has to show a compelling governmental interest. In other words, is it absolutely necessary for this particular group to attend school when they can be taught at home? And the Supreme Court ruled that Wisconsin did not have a compelling interest to force this particular religious group to send their kids to public school, and ruled against them. All right. So that was in 1972, and those tests that I mentioned to you were the ones that were followed in 1972 all the way up until the 1990s. In 1990s, a very interesting case comes up in the state of Oregon, and this involves Native Americans. This guy named Smith. He was working for a state agency that provided treatment for addiction and so forth to people. And it turns out that this guy was he was a Native American. And outside of work, he would exercise in what's called smoking peyote, which is like marijuana, but very strong marijuana. Okay, so when the government found out, the county that he worked found out they smoked this publicly and elsewhere, they fired him because it was a violation of a criminal law that says you can't smoke, drugs and so forth. You can't take drugs. So they fired him. So he said, "Oh, wait a minute. Peyote is part of my Native American religious practice. So you violated my right. Okay? So I want to smoke dope. All right? And it's part of my faith." So what do you think happened here? Did they apply the strict scrutiny test and say, wait a minute, government, you are imposing this burden on this guy's religious rights, so therefore, you lose. What do you think the government did? I'm sorry, what do you think the Supreme Court did?
In favor of this guy?
They what?
In favor of this guy?
You would think so, right? Yeah, based on what we just did with Werner and the Yoder case in Wisconsin, you would think that. Nope, he lost. Well, let's see. I don't. Yeah, it lost because at this time there's a new justice, not new justice, but he was around for a while, named Justice Antonin Scalia. Justice Scalia became a very important, powerful, conservative justice. Very smart too, very brilliant. And he was very hardcore on certain issues, and this was one of them. He was very sort of pro-government when it comes to criminal law. He established a new test. He said, look, we're not going to adopt the three-prong analyses of the Lemon test or the other tests, strict scrutiny. Instead, we're going to say this. If you have a general law, a law that is general in its outlook, that it's not targeting a particular faith or a community, and if it's for the welfare of the state and government and the community, then that law prevails, even if it may be run afoul or contrary to a particular religious practice. Now, he came up with this test, which ultimately other justices signed on to, and therefore they ruled against Smith. I think he did this because he realized this guy was using religion as a way to smoke dope. Okay? But how do you get around the strict scrutiny tests that the Supreme Court had laid down? He came up with this new test called the general law of general applicability. So if the law is general in nature, it's going to affect some people, obviously, but generally, if it's not targeting a religious faith, that's what we look at. So Smith loses, he can't do dope anymore. The next important case, and then I'm going to skip ahead, is a case called the Church of Lucumbalua. This was in Florida. And this is interesting. What happens is you have a group of people, they're from the Caribbean, who practice a religion called the Santeria religion. Okay, you've heard of voodoo and things like that, right? It's kind of like that. That's a negative way of saying it, but they engage in different kinds of rituals. One of the rituals as part of their religion was they would slaughter chickens. And they would kind of put the chicken's blood and so forth on this altar, and then they kind of worship and things like that. Yeah. Okay, thank you. So, they were engaging in these activities at the churches and so forth, and the local town, at what's called the city of Hialeah in Florida, found this out. So they passed a law saying, from now on, we will not allow anybody to slaughter chickens outside. That was literally the law. Okay. So it didn't mention the name of the church. It didn't say Santeria or any of these people. It just said we will not allow this kinds of activities in our village or city anymore. So they sued in federal court. The city wins in the federal district court. They go to the 11th Circuit, the appeal court. The city wins again. The church loses twice. Then they go to the Supreme Court, right? Supreme Court says, city, you lose. Why? Because here, Justice Kennedy wrote that even though just a few years ago, 3 years ago, we ruled in the Smith test that this was a law of general applicability, similarly, the ordinance in the city here was general, it didn't target the religion. He said, we're not really that stupid. We know exactly why you passed this law. You passed this law to target this religious community. Therefore, we're going to say that this is really not a law of general applicability. It was meant to target this religious community because you didn't like what they were doing. You just didn't like this chicken slaughter that's going on in public. Okay? And the law was not facially neutral either because of what's going on. Because there's nobody else who's doing this. It's just not a problem in the city. You know, there wasn't like a mass movement of people slaughtering chickens on the streets or something. Okay? This was a little activity that this church is doing, and you targeted that church community. Therefore, we're going to rule against you, and the city loses. Okay? So this is a very important case for religious minorities whose faith and practices are being targeted by the government. And noted, this is not a federal government. This was a city that was doing this. All right, anyway, so you have all these cases. I'm just kind of highlighting all these different cases that have come about recently about these kinds of issues. The most important recent one was called Kennedy versus Bremerton. That came out in 2022, whereby a coach, a football coach, started after each game, would go to the center of the field and start praying publicly. And then all his students would come around and other people would come around and start praying. So the government, the state, sued him for that. And it's interesting because he actually won. And there's a real historical interesting aspect behind that. But what I want to do really quickly is skip ahead and go to this. So a few years ago, maybe about 10, 15 years ago, these various states started passing what's called anti-Sharia law. You may have heard that called anti-Sharia legislation. So it was led by this Orthodox Jewish guy from the East Coast who basically was trying, his name is David Yerushalmi, which Yerushalmi by the way means Jerusalem, ironically enough. And he got all these states to pass anti-Muslim legislation where it says that the law, our state cannot adopt and will not allow the adoption of any Sharia law. And one of the states was Oklahoma. So a Muslim attorney with CARE sued the state of Oklahoma, even though that law, the anti-Sharia law, passed with 70% approval. He sued and he said this is a violation of the free exercise clause. Okay? And the Oklahoma Supreme Court ruled in his favor. He won. So that was nullified. So that's just an example of things like how this free exercise clause can help. Actually it was not the Supreme Court, it was the Ninth Circuit, the affirmed court ruling that the Oklahoma statute violated the Establishment Clause and the free exercise clause. Two other interesting cases, really quick, you may have heard these, is the hijab case and then the Muslim prisoner case. So these two cases don't involve, they kind of involve the free exercise, but they also involve other laws. One law was the first one I mentioned, which is the 1964 Civil Rights Act known as Title VII. Title VII says that in employment cases, an employer cannot discriminate on the basis of race, national origin, religion, color, or gender. So you can't discriminate a woman because she's a woman. You can't fire somebody because of their national origin. You know, that means if you're Turkish or Indian or whatever, or race, if you're black or a Muslim or a Jew, whatever. So this woman was interviewed. She wanted to work with Abercrombie and Fitch, which is a clothing store. And she went and applied. And during the interview, she was told that if she wanted to work, she would have to take her hijab off. Otherwise, she can't work. And they said, oh, you're qualified, you're great, but you have to remove the hijab. Otherwise, we can't hire you. She sued under Title VII. She lost at the federal level. circuit level, it goes to the Supreme Court. Supreme Court rules in her favor and says that Abercrombie and Fitch discriminated against her on the basis of religion under Title VII, plus it was a violation of the Free Exercise Clause. Okay, pretty phenomenal. Yeah. The other case is called the Holt versus Holmes case, which is this guy here. Why is this important? This guy was a Muslim prisoner, and he committed some really violent act. I think it was kind of like either some kind of physical harm against somebody or murder or something. Anyway, so he goes to jail, he's in prison, he converts to Islam, this white guy. He converts to Islam, Mr. Holt, and he starts growing out his beard in prison. And then the prison authority says, you can't grow that beard more than, half an inch. That's our limit. And he says, well, I need to grow it this long because it's part of my faith, fist length, whatever. So they said, no, it's a violation. If you persist, then we will fine you and so forth. So he sues. And when it goes to the court system, federal court system, the prison authorities say, well, reason we have this policy is because people can hide razor blades in their beards. Therefore, it could be used as a weapon. So the federal court agrees and rules in favor of the prison. It goes to the circuit court. The circuit court agrees. It goes to the Supreme Court. Supreme Court says, oh, come on, give us a break. And they rule against the state, I think it was Arizona, and against the prison in favor of this guy. 8-1, I think it was. 8-1. In both cases, it was predominant views here. And against Scalia, the one that ruled against Smith in Oregon, he ruled in favor of this guy. So this is the act that this guy relied upon, which I mentioned to you before, which is the Religious Land Use and Institutional Persons Act, which is our LUPA. What's interesting about this act is it has two components. One is one component deals with churches, synagogues, and mosques, and the other one deals with religious prisoners. This was passed in 2000 because people felt that prisoners in prison were being discriminated against because of their faith. The wardens wouldn't let them practice Islam or Christianity or whatever, so that's why they passed this. This is important because it applies to persons of religious assembly like churches and mosques. So if you want to build a minaret, if you're a masjid, you want to build a dome or a minaret, and the village says, oh, you can't do that because of height restrictions or because of whatever reasons, that's a violation of this law, and you can use it to your advantage. A lot of mosques in the in Chicago area did not build minarets and domes because they were scared or because they got pushed back from the village, and they did not know this law existed. And they could have won if they knew this law. Similarly with prisoners, if you have Muslim prisoners and they want to practice their faith, they need halal meals and things like that, the government has to provide this for them under this law. So this is a very important law that a lot of Muslims don't know about. Here's a case. And then there's others that came around. So anyway, I'll stop here. So if you have any questions, thank you very much. Appreciate it.